Speaker.
I recognise the honourable member, Andrew Little.
Kia ora. Thank you, Mr Speaker. And I rise to once again pledge the Labour Party's support for the bill, but to also express our continuing concerns about it. The Minister says that there are 60 failed finance companies now that are known and recognised, that 22 of them have perpetual trustees as their securities trustee, perpetual trustees being the trustee company that is presently before the High Court seeking to have the public trust appointed as the trustee because of the conflict of interest that Perpetual Trustees now has as a defendant in litigation by the receivers of Capital and Merchant Finance, for which it was the trustee. If we can sort of get our heads around that string of relationships, life will be a lot easier. But the reality is, sir, that there is only one application before the court to appoint the public trust as a securities trustee, and that is the application by Perpetual Trustees in relation to Capital and Merchant Finance. None of the 22 other finance companies also having Perpetual Trustees as their trustee have any applications, and none of the 38 other of the 60 failed finance companies have any applications before the court. So let's not overstate. Let's not overstate the risks and therefore justify urgency when urgency may not be justified. There are, putting aside the aspect of urgency, we do accept that as a matter of policy, of good public policy, that protecting public trust in relation to these applications is a good idea, because trustee companies are the very ones who are quite happy to clip the ticket and watch the lucre rolling in during the good times, and then when it gets too hard, when the finance companies are up against it, when the borrowers that they've lent money to fail to repay the loans, when the depositors are demanding their money back, their capital back, they are the ones first to try and get off the scene, to absolve themselves of responsibility. And if they find as a little trick they can now get the public trust to step in, and therefore the public purse and the state to step in and protect or shore up the failed private sector, which the private sector is notoriously good at doing, then I agree with the Minister, they will no doubt try to do so. But at this point in time, given the facts also about the litigation by Perpetual Trustees, we see no sign of that, no impending sign. And introducing this bill with a specified date so that we could go through a proper process, take advice, talk to the professionals in the field and understand the true impact of what we're doing and the risk associated with it, that would be much more preferable. And I would like to think that if the Minister or any member of this executive is in the same situation in the future, that when it comes to a choice between applying or seeking the urgency of this House, the urgent attention of this House, and looking for alternatives that provide the sort of protection that could be given by specification of the date in this bill and allowing a proper process, that the executive and any minister would always err on the side of a more open and fulsome process. That must be a driving principle when it comes to the management of legislation through this House. No matter how quickly it needs to pass, no matter the issue, and no matter the perceptions about the magnitude and the significance of the issue, we must be assured, and the public of New Zealand must be assured, that the executive does not take for granted the time of this House and our goodwill and our ability to provide proper and decent scrutiny of important legislation such as this is. So, sir, we understand the public policy, and we hope that that will be translated into a more progressive view about regulation and intervention in the finance markets, because the truth is they have for a long time been the cowboys of our economy, and many of them remain still so. They were allowed to get away with it. We had the financial collapse in 2008. The risks that this bill is addressing were known since then, but we are still plunged into urgency to address that issue. And, Mr Speaker, we simply should not be put in that position. That should be, this is a bill, funnily enough, about last resort. It's appointing a trustee of last resort. Well, when it comes to last resort, urgency in this House should be an option of last resort for those who have the responsibility for managing legislation through it. So we have to place that on record. That remains a very clear and unequivocal objection that we have, that this House should be treated in that way on matters such as this. The risks that this bill is trying to manage and dealing with can be mitigated in other processes that this House typically employs and could have been employed in this particular case. We understand the issue about not wanting to expose the public trust, to have to pick up the tab for failing finance companies. The reality is the very one application that is on foot in the High Court presently will not be covered by this bill. And so capital and merchant finance, once again, will find itself off the hook. Perpetual trustees will find itself off the hook. The public trust will no doubt be put to expense and inconvenience to pick up this role, if indeed it is awarded that, or at least it is appointed by the court as the trustee for capital and merchant finance. But that is a cost that will be borne. And so that one has escaped the net. The public purse will be affected, and we haven't acted fast enough to prevent that from happening. But there is no evidence of any other proceedings on foot or that could be on foot. The regulatory impact statement acknowledges that it is inadequate, but it also does not advert to any other proceedings on foot. So we simply do not accept that there is that level of risk there. So, we just want to make the message very clear. We understand the importance of this. We understand the importance of having good regulation now around the finance markets. The last Minister of Justice shepherded through legislation in part to achieve that. This Minister of Justice is managing through the Financial Markets Conduct Bill. That will make a difference too. But then the question remains whether this particular bill, being dealt with under urgency, is a matter that needs to be dealt with as urgently and as precipitously as it is being dealt with at the moment. And that's what we object to. And we should always, good parliamentarians should always object to being put upon by the executive in this sort of way. And perhaps members, backbenchers and the party opposite the party in government, maybe they will express that as good, honourable parliamentarians as well, express their view that they also don't wish to be treated in that sort of way, because urgency is, I repeat, ought to be a procedure of last resort, not a matter of first resort as it appears to in this particular bill. So we will support the bill, and we support the underlying policy in the bill, but let us not be put in the position again when we are dealing with these issues, when we haven't had the benefit of hearing from the sector, others in the sector apart from perpetual trustees, even the receivers of the various finance companies, and others in the finance sector, and indeed trustees who have been put in this position, or been in the position of being a trustee of a finance company and the implications for them. We haven't had the benefit of their insights and their experience, and that is a dangerous position for us to be in. So we underscore that clearly, and we highlight it with the biggest highlighters, and we underscore it in red ink. Please ensure that this House and every member in it is not put in this position again, because it is not good for Parliament, it is not good for parliamentarianism, and it is not good for New Zealand.
The question, I call the Honourable Member Alfred Naro.
Thank you, Mr. Speaker.